Okay, welcome to the Committee on General Laws. Mr. Secretary, call the roll.
Senator Onder.
Here.
Senator Wieland.
Here.
Senator Brown. Senator Nigel. Here. Senator Hummel. Here. Senator Paulson. Here.
We have a quorum. The quorum being established, we'll be executing at the end of this committee meeting. Our first bill will be presented by Representative Taylor, House Bill 251. And whenever you're ready, go ahead.
Thank you, Mr. Chairman, members of the committee. Appreciate you hearing my bill today. House Bill 251 is paycheck protection. I believe that Senator Brown had the exact same language, and you've heard that already this year. But I'll hit the highlights. So this bill would require written or electronic authorization for the withholding of dues, agency shop fees, or other fees paid to public labor organization. It would also require annual authorization for dues, agency fees, or shop fees, or other fees to be used for political purposes. And it would also require the unions to make available to all members a searchable financial summary. With that, I'll be happy to take any questions.
Thank you, Representative. Of course, this bill was heard here already, but do any members have questions of the sponsor? Seeing none, do you have witnesses in favor?
Yes.
And I think what we'll do is go, in interest of time, we'll go 3 minutes for, 3 minutes against, 3 minutes for informational purposes, alternating, and let's get started. Great, thank you.
Thank you, Chair Committee. My name is Jeremy Cady. I'm the State Director for Americans for Prosperity. We have heard this before, very similar to the Senate version, and we just want to go on record in support of it as well.
Any questions from Mr. Cady? Seeing none, thank you for testifying. Remember your witness form. Next witness, Otto.
Opposition.
Opposition.
Otto Page on behalf of Missouri NEA. We believe this bill is unnecessary and infringes on the constitutional bargaining rights of public employees. Under 300, these provisions have essentially been covered in a more easily implementable way that school districts have been able to deal with since 1983. And so we think that's preferable. This creates a separate, parallel, potentially conflicting structure. And so we think that the bill is unnecessary and problematic for both the employees and for management.
Yeah, thank you, Otto. I'm sorry, what happened in 1983?
That was the passage of whatever the bill number was. I think it was House Bill 895 to create 168-300. That created the law that has been in effect for all education employees. It says that school boards may do voluntary deductions of a variety of types, must be done within 15 days as directed by the employee. Has to cover in a fair and equitable, non-discriminatory basis all requested types of donations, and if the district incurs any incremental cost, that the employees must compensate.
And that's 168-300,
Yeah.
as opposed to the public sector labor law passed in 105, 557, and 105. Yeah, okay. Thank you. Further questions? Seeing none, thank you for your testimony. Remember your witness form. Testimony for informational purposes only. Testimony in favor of House Bill 251.
Mr. Chairman, members of the committee, Brian Johnson, President of the Missouri Women's Recruitment, just wanted to
Thank you. Any questions of Mr. Johnson? Seeing none, thank you for your testimony. Further testimony in opposition to House Bill 251.
Good afternoon, Chairman, honorable members of the Senate Committee on General Laws. For the clerk's record, Clark Brown from Missouri State Council, SEIU Service Employees Union. Had some relation to this legislation. We have about 13 public contracts that we do voluntary union membership activities with and operate by. I guess just in a few fundamental points. Again, I think that some experience in seeing this legislation the last 10 years, we've seen, 6 different hearings, a couple of times vote, even a passage and a veto override. We certainly, want to remind you that this legislation keeps coming back. And I think with fairness to say, when we look at the sponsorship and authorship of this, is this truly a reality issue? Do we see public entities, public bodies here saying they want this legislation? Do we in fact even see the workers here saying we want this period of choice of re-signing every year to become union members? I think we should probably look at the thoughts of our typical process now. We had 3 contracts with the state of Missouri. There was probably a few thousand in those various groups: mental health probation officers and correction probation assistants. The state sets the standards for the type of card that we use, and I'd be glad to submit that. I think this legislation is proposing a specific style of card with specific language to be used, specific type of font to be in size and print size. And I think maybe that's some overreach when the facts or the details expose the state of Missouri's the one that designs this card for us and approves this card. So that currently, in my thoughts, is a little conflicting to want to propose the standards for what these membership and union cards should look like when, frankly, we do that practice individually with the public employers and let them have the jurisdiction or approvals of what the cards read and look like. I also want to make a point to this legislation. While most public employees in this state, and certainly our 13 public contracts, union membership in a public union is voluntary. So they sign up when they want to sign up. They withdraw when they want to withdraw. I think we start this annual process of annual reauthorization. We're probably going to be sending a message to workers that may not be in the fine print, but I think that they're clearly going to think that they are signing in for a year, and that they get the choice of re-signing when this annual period comes back around. But I think that's contrary to the practice now. I mean, there may be sometimes we visit a worker on an employee orientation and take a few minutes of talking to them, decide a union card, and 3 months later they're like, I've changed my mind, I want out. And that's currently the practice we do. I think that this kind of legislation is going to be very misleading to the workers. Outside of that, I think that's all I probably wanted to state here. I think it was spoken. We think that this is unnecessary. We think the practice now is pretty much governed and set by the public entities about the type of card and whether or not they want us to annually sign it. I think they could certainly negotiate that if that's what they wanted, if we need to do it. I end with thoughts of, it's been a couple of years. I did sunshine request with Office of Administration here in the state. There are 2 years ago, 75 approved payroll reductions. Only one of those require annual reauthorization, and that's the Missouri State Charitable Employees Fund. And I think that the state wants to set that standard because there are like 437 authorized organizations that get approved in that list, and it's constantly changing. So every year, because an employee may choose to do $5 here, $3 here, they want the employees to go back and look at the list, make that decision if they remain where they steer those contributions or if they make some changes to it. But that's the only one I know other than federally set standards like, wage garnishment for child support or something like that. But That would be the only one that I know of saying. Thank you.
Thank you, Mr. Brown. Any questions of this witness? Seeing none, thank you. Remember your witness form.
Oh, also, I want to put on the record, with the International Union of Painters, Bruce Holt, also Missouri AFL CIO, Mary Berry.
Thank you. Further testimony, any testimony, I'll do informational purposes only one more time. Any further testimony in favor of House Bill 251? Further testimony in opposition to House Bill 251?
Chairman and Senators, my name is Sherwood Smith. I'm President of the Missouri State Council of Firefighters. We represent firefighters, EMS workers, prosecuting attorneys, and dispatchers across the state of Missouri. I speak against this bill. I've been here before, and I hope that some of the things that we talked about previously was researched. I would say there's some things that I do want to point out. One of the things is, out of 36 affiliate locals in the state of Missouri, 27 of those affiliates for the secretary treasurers, the presidents, the leadership that would be tasked and held accountable if this bill would be passed, make $200 or less. There's only one local in the state that has full-time staff. Other than that, other than 35 have no staff. Of that leadership, all of those members, the secretary of state, the secretary treasurer, the president, they are expected to do the duties of their office. Many return to the fire station. I just recently retired, but if I had still been on the fire department in Kansas City, when I leave here today, I would be expected back at work as soon as possible. And those are some of the tasks that we face. And the fire service is different. We don't just pass down the hallway and say hello to somebody that we barely know. 1/3 of the year, we live with the men and women that are part of our association. And what that entails and what that grows from us is that our members have a voice. They have a voice too. Now, of course, the guy who just came out of the academy is not going to speak like a 15-year guy. But believe me, over time, sitting at the dinner table and as he becomes more acclimated, he will voice his concerns about whatever they may be, if it's political, if it's religious, if it's the union. And so to this bill speaks as if somebody is being forced to do something that they don't think they should. But I also like to point out that one of the things that, with all due respect, I believe this bill tries to address some of the things that I think is my job, the job of the leadership of our association. If there is a member in Lebanon, or Kansas City, sitting someplace and think that they don't have a voice, I would expect them to call. Believe me, I do get calls when something doesn't go the way they expect it. Whether they're right or wrong, that's my job to make sure. That's our association job to make sure that those individuals' voices are heard. I'd also like to point out that the transparency, we have no problem with transparency. In fact, transparency is built into our constitution and bylaws. At every union meeting, the previous month's expenditures, whether it's receipts or whatever, must be read. It must be readily available. Usually just, they type it out and you can do it like that. Now, of course, every union doesn't, every local doesn't meet it. It depends, if you got a 20-man local, like Chillicothe, for instance, they have 26 guys. They don't meet every month. They meet once a quarter. But whenever those meetings are held, it is in our international constitution bylaws. In those minutes, there must be a reading of whatever has transpired since the last year. Currently, our members right now have a method of withdrawing from the union at any time. They can do it electronically. They can call this political subdivision. They can call their union representatives, or if they were to call me on a Sunday at 8 o'clock or something like that, I would simply tell them go to the website and withdraw. You can do that in the sanctity of your own home, without, if you would think that they might be pressured to, hey, why don't you stay in or something like that, just do it. I can tell you, by being kind of the warehouse for our different locals, is members go in and out every month for different reasons. You know, they're short of money this month or this and that and the other. So that is not a problem. There has never been a problem for us.
We're at about 4.5 minutes, okay? Is that,
I think
some, okay. Questions of this witness? Senator Lappel.
Thank you, Mr. Chairman. I'll be pretty quick. About what percent of your employees are the union? Let's take a guess. If you don't want to.
In Kansas City, there's 1,700. There's 3 that are in.
3, you say?
3 out of 17.
3 individuals?
Yes. Just about every local has 100% participation. I think St. Louis City, due to some historical background stuff, they probably have.
Thank you very much. Thank you.
Questions? Yeah, Senator Rizzo.
So I believe earlier we talked to somebody said something about a searchable database. Is that correct?
Yeah, yes, that's correct. It's in the bill for financial summary to be a searchable format.
And to the witness's point, that's obviously something that would be undertaken by the local. And to your point earlier, what you're basically saying is there's going to be firefighters that will be taken, maybe not taken off the job, but given an extra duty to put that stuff together.
Yes.
But to your credit, you guys kind of already do that.
Yeah, well, they'll have to incorporate this bill further to their daily duties, add it on to their duties that they do now as leadership and as firefighters and serve the community.
I'm just trying to wrap my head around mandates and all that type of stuff. So thank you.
Further questions of the witness? Seeing none, thank you for your testimony. Remember your witness.
Thank you.
Further testimony, I don't think we had any more testimony in favor of House Bill 251. Further testimony in opposition to House Bill 251.
Mr. Chairman, members of the committee, Mark Bruns on behalf of the Fraternal Order of Police. Don't want to be repetitive, so I'll just say that we have a lot of the same concerns that the firefighters do. Add a couple of things real quick. It's really easy for our members to opt in and opt out. They do it all the time. And one of the main reasons why our members join is for our legal defense fund. And as you know, in this day and age, police officers are under a lot of scrutiny, and a lot of them are one trigger pull away from being under the thumb of every newspaper in the state and nation, the Justice Department, and everyone else that wants to find out what was going on. So our legal defense fund stands ready to help these officers, and there's been well-documented cases around our state in the past where we've been there for them all throughout their ordeal. So we just don't want to make it any more burdensome for our officers to be able to access that.
Questions of Mr. Bruns? Seeing none, thank you for your testimony. Remember to fill out your witness form. Further testimony in opposition to House Bill 251.
Yeah, Mr. Chair, honorable members of the committee. For the record, my name is Richard Craig with the United Steelworkers of Missouri, FLCI. And to make this fairly short, we just won't go on record being opposed to this.
So do the steelworkers have any government contracts in the state?
We've got some public employees, yes.
You do
It's
have
a
some
small group. But
Yeah, they do represent some public employees. Okay. Do you know in like what context?
It's a water district.
Water district. Okay.
Up in, I think, Independence, Missouri.
Got it. Okay. Thank you for your testimony. Any questions of this witness? Thank you. Seeing none, remember your witness form. Further testimony in opposition to House Bill 251. Going once, going twice. This will conclude the hearing on House Representative. Do you have any concluding remarks?
No, thank you.
Thank you. This will conclude the hearing on House Bill 251. Our next bill will be Senator Wieland presenting Senate Bill 358. ready, go right ahead.
Thank you, Mr. Chairman, members of the committee. For the record, I'm Paul Wieland, Senator from 22nd District in Jefferson County. Thank you for the opportunity to present to you today Senate Bill 358. What 358 says is that a bargaining unit within the Bi-State Development Agency may choose to be represented by any labor organization for the purposes of collective bargaining. However, such bargaining units are not required to be represented by a labor organization. The Act further requires that the Bi-State Development Agency to settle labor disputes involving representation by arbitration, and that labor disputes resulting in an arbitration award shall be final and binding. Because these bills deal with the Bi-State Agency, we have to mimic the Illinois law for them to be effective. Mechanics for the Amalgamated Transit Union Local 788 brought me the idea for this bill. Their union consists of around 1,000 members that are Metro drivers and around 285 mechanics. It's the feeling of the mechanics that when the collective bargaining occurs, the union doesn't always look out for their best interest and instead leverages the contract proposals towards satisfying the larger group of drivers in order to ratify collective bargaining agreements. The mechanics have been unable to remedy this internally. They've tried to join another union, they've tried to go to court, but because this is a bi-state agency, the courts have claimed that they don't have jurisdiction, and finally they are turning to us in the state legislature. I have a witness that works for Metro, the bi-state agency, which will share his story and explain to the committee why this act's needed, but I will try to answer any questions that I can.
Thank you, Senator. So right now, if I get this straight, so the drivers and the mechanics are both represented by the same union, and that was what
The amalgamated
yeah,
transit local union local 788.
788. Okay, so we really kind of have a bargaining unit issue here, where you have two groups of employees that maybe shouldn't be in the same bargaining unit, but they.
That's I guess what the argument could be made. Yes.
All right. Further questions of the sponsor? Seeing none, thank you for your testimony. Any witnesses in favor of Senate Bill 358?
Mr. Chairman and members of the committee, thank you for your time. My name is Michael Stenger. I'm a 17-year member of Amalgamated Transit Union Local 788 and a 17-year mechanic with the Metro Transit Agency. I have 4 pages of notes here, and I'll try to keep it much more brief than that. The mechanics and bus operators are lumped into the same contract. We are all part of the same union. Our caller ride van operators and our clerical workers are all part of the same union. Our clerical workers and our caller ride van operators have their own separate contracts. We are the only groups that are lumped into the same contract. This has been a point of contention between the drivers and the mechanics as far back as I know, and from everything I've heard talking to other mechanics from farther back, even today. We've tried to get our own contract. 4 years ago, in the summer of 2013, the mechanics began a process of trying to separate. We sought other unions. We sought petitions taken straight to the company and the board of commissioners. They chose to remain neutral and still remain neutral to this day and say that it is an internal union matter. When you have 2 extremely different classifications in the same contract, it creates a natural conflict. Our issue with being in the same contract is not that we are against the drivers. They do an extremely difficult job that I would not want to do, and we have some of the best drivers in the country. The issue that we have is when it comes time for contracts, we are outnumbered at least 3 to 1. There go 1,000 drivers, 900 to 1,000 drivers, 285 mechanics. And we feel that naturally that will sway contract negotiations to the larger group to get a contract ratified. The issue we have is working for Metro, which is part of the Bi-State Development Agency, is an interstate compact. As such, we are not covered under any labor board whatsoever. We cannot seek the assistance of the National Labor Relations Board. We cannot seek the assistance of the Missouri State Board of Mediation or the Illinois Labor Relations Board. We are not considered public employees, nor are we considered private employees. We literally have nowhere to go. The Missouri State Constitution and Illinois statute
You know, Missouri's Constitution, Article 1, Section 29 provides the right to collectively bargain to employees. And in cases in 2012 involving the teachers and police officers, they said that when processes aren't available, the company is required to provide those processes in order to collectively bargain. We filed in federal court. Our union joined that lawsuit against us, arguing against our side. And the federal courts and our union attorney stated that this is a legislative issue. That is why we are here. We are seeking the Missouri legislators' help in remedying this injustice. The Illinois legislature and the Illinois Labor Relations Act has already addressed this situation and provides a process, and we are simply trying to mirror that language. We're simply asking for a fair and equitable chance to resolve our situation. We're not asking for you to remove us from our union. We are not asking to separate from our union. We are simply asking for our own separate contract, which is a common practice across labor lines. With that, I thank you for your time and will answer any questions that I can.
Yeah, thank you for your testimony. That was very helpful. And as I was reading this bill the last few days, my big question was how I've been aware of this issue with the drivers and the mechanics for a long time. My question was, how does this bill fix it? And I guess the answer is what you just said. Right now, you don't have access to NRLB or the State Board of Mediation in Missouri or the equivalent board in Illinois. So that's your problem. You don't have access to any mechanism of resolving disputes.
Correct. And we are not asking the legislature to separate us.
Right.
We're simply asking for a process whereby we can try to pursue it. If it works, great for us. If it doesn't, at least we had a fair and equitable shot at trying.
And you have an interstate compact here. Is the language we find in this bill here already present in Illinois law? So, you know, that's
yes.
Okay.
This is a portion of a section addressing by state in the Illinois Labor Relations
My
Act.
able chief of staff has that right here, and that's what he was pointing out to me. Okay. So, and so as we go forward with this bill, if we all like it, we probably don't want to mess with semicolons or commas or anything, because the minute it becomes, my experience with compacts in the past, you change anything and they're not identical, and that's
the biggest issue. Okay. Is they have to be as closely parallel as possible.
Well, thank you for your testimony. Further questions of this was Representative Hummel.
Thank you, Senator. And this may be for either one. To your point, I had the same thing. I've heard about this for a while, and my question is this the remedy? Is this, if we do this, will that automatically ensure that, or because, and I don't know the federal rules regulating this, even if we mirror Illinois' language, will that then automatically ensure that this happens, or is there some federal requirement that will not actually allow it to happen? I mean, is this a silver bullet, or is this just a shot to get to that point, and does federal regulation supersede this? That's my question. I honestly don't know.
I'll answer that because I've been researching this stuff for 4 years now. So, to be honest, I'm not fully sure.
Okay.
This is a shot at trying to remedy this. Everything that I've researched from court cases, Supreme Court cases across the board, as long as legislation in both states has the same intent and is parallel in intent, then it can apply to the compact. As long as it doesn't change, as long as it doesn't burden the compact or change the overall powers or intent of the compact. That is why we're pursuing this. As far as I can tell, it does not need to go any farther than the 2 states to the federal government for approval in that situation.
So it's only because the language is not mirrored in both states. Is that correct?
Correct.
That's your understanding?
Yes, one state's laws cannot unilaterally apply to a compact.
Okay, thank you. Appreciate it.
Right, and that was a really good question, because the compacts have the force of federal law, and to establish the bi-state, it was bi-state first and now metro compact, it actually took not only the Missouri and Illinois to pass a bill, but Congress had to act as well. But to your knowledge, we can change Illinois and Missouri law in this respect, and
to my knowledge,
we're good to go. Yeah, that would be my impression too. Further questions of this witness? Seeing none, thank you for your testimony. Remember to fill out your witness form. And if you have more extended, notes, feel free to submit that as written testimony. Further testimony in favor of Senate Bill 358.
Mr. Chairman, members of the committee, my name is Tim Dempsey. Next month I will have 30 years at Metro. I'm also a 28-year veteran of the Missouri Air National Guard. I'm here in support of this bill. I think Mr. Singer pretty much covered all of the facets of it. And basically, we're just asking for the same rights, just like the union members that were here previously. They all have this right. And that's all we're asking for is the option to exercise this right. And like you guys just discussed, is this a sure thing? No. Because Metro, nobody really can give a specific definition of it. So, but without this bill, we don't even have that opportunity. And every other union in the state and every other union in the country, unless there's some just like ours, which there might be one or two, they all have this opportunity, and that's all we're asking for.
Thank you for your testimony. I do have one question I should have directed at Mr. Steinberg. Is he any relation to the St. Louis County Executive that we know?
None that I know.
None that you know. Okay. My family, I grew up with the Steinbergs in St. Dominic, Salvia. Further testimony in favor of Senate Bill 358. Any testimony in opposition to Senate Bill 358?
Thank you, senators and committee. My name is Jim Fall. I'm here representing Amalgamated Transit Union Local 788 in opposition to this bill. Traditionally, when this bill has come up before, we only testified for information purposes only. This time we are actually testifying in opposition to this bill for a number of reasons. First and foremost, because this is an interstate compact, I think there is a lot of misunderstanding. The passing of this bill alone does not change or does not give the remedy that the proponents of the bill are advocating. An interstate compact is a creature of three distinct sovereigns, two distinct sovereign states and the federal government. Even if the two laws are the same on both sides, without the blessing of Congress, the law has no form or effect. Further, the Illinois section that is being referenced has nothing to do with unit clarifications. It has to do with initial bargaining unit determinations, which is distinctly separate from what's in this bill and what is being requested by the proponents. This is very confusing, and I understand why. I have been involved in cases involving interstate compacts, and have read, I think, just about every case there is regarding the bi-state interstate compact, and had to read them multiple times because they are indeed confusing. But one of the cases I think is illustrated, and that is the KMOV-TV versus bi-state. The situation there was KMOV-TV in the St. Louis area issued a Freedom of Information request to bi-state. Bi-state said they did not have to comply to the Missouri Freedom of Information request. They took it to court, and they claimed, bi-state claimed, that because it is a compact, the Missouri Sunshine Act does not apply to it. KMOV pointed out that the language and the things sought under the Missouri Sunshine Act were very similarly worded and identical in purpose to that of the Illinois Compact, or Illinois Sunshine Act, and very similarly worded and identical in purpose to the Freedom of Information Act that is federally governed. And the court in that case said that very well may be true, but because it wasn't an agreement to affect bi-state that way between the two states, that the federal government then blessed and allowed to happen, neither state nor the federal government applied to this bi-state compact. That's because this is a foundational purpose, a foundational idea in our Constitution when it comes to the compact clause. Regarding representation, the union would point out that the mechanics are very well represented. In recent negotiations, the mechanics got a larger raise as a percentage than the bus drivers. The mechanics receive a tool allowance that obviously the bus drivers do not need, and the mechanics actually need and do deserve and should probably get more as well. If you were in the meeting for the ratification vote, you would have seen what I saw, where when the contract is explained, for every driver that stood up and said, it's not fair that the mechanics are getting a bigger raise, there would be 2 and 3 drivers who stood up and said, it's absolutely fair that they're getting a bigger raise than us because they're underpaid. Also, I know I stated that traditionally, union has testified only for information purposes and not in opposition. That changed under the recent election of the Amalgamated Transit Workers Union. Under the current election, there was a change in leadership. Among that change in leadership, the president is now himself a mechanic from the unit of 200 that was elected by the 200 plus mechanics, as well as the nearly 1,000 drivers. The mechanics have a seat at the table. Further, this is a big contract. For a number of reasons, this is a very large and complex contract. I think to see a lot of union labor contracts, and this one is very detailed and very large. But if you're involved in those negotiations, as the current president of the union is, you would see something very interesting. You would see that when things having to do with the entire amalgamated union are discussed, a mechanic contingent and a driver contingent sit at the bargaining table. When there's issues regarding that are particular to drivers, driver safety, driver pay, driver training, the mechanics, while in the room and giving their 2 cents, sit in the back. When the mechanics, things come up regarding them, wages, training, tool allowances, which are substantial and required because they serve a very important skilled position, the drivers sit back and let the mechanics negotiate those portions of it. That's the purpose of an amalgamated union, as the ATU is that portions of the industry are negotiated together. One final point, and then I open to questions, is something interesting in this, which gets to the point that this bill does not talk about unit clarification, which it seems that proponents want. And that's shown in the part regarding labor disputes involving representation. In that position, it sets out a framework for arbitration. And you'll notice that the parties to that arbitration are the union and the company. And they pick a third. This was about unit clarification. Why are the parties the company and the union for which this organization is trying to separate? Not separate from the union, you know, as the brother stated, they don't want to separate from 788, but to have a separate unit. And it's both. That doesn't make sense if it's for unit clarification. It doesn't make sense that the company would have a say and be a party to the dispute that it is not involved in. It doesn't make sense that the other group would not be a party to the dispute in the arbitration that it does say it is involved in. Finally, if the issue is talking about different bargaining units and there are many different bargaining units, as Mr. Stanger, Brother Stanger alluded to. Some represented by amalgamated union 788, some in the same amalgamated contract, some in separate contracts, some represented by different unions entirely. They're members of IBEW locals that bargain with Metro and our Metro employees. So with that, I'll entertain questions.
Okay, thank you. So your testimony is that this bill alone, even coupled with the Illinois statute, doesn't give the remedy that Congress would also have taken.
Even more nuanced than that. Illinois and Missouri would have to come together and say, this is an agreement that we agree to affect by state. Congress, will you bless it? So even Missouri acting unilaterally, the way I read the case is say word for word, which even if they say word for word, if Illinois says, well, yeah, but we didn't mean for that to affect the compact, that was just for our workers.
Okay, so they would, each state would have to have a separate bill meant to affect the compact. That's.
Each would have, my understanding is each would have to have a separate bill saying that the intent of this is to form an agreement between Missouri and Illinois for these purposes that will then be enshrined in the codes and statutes of each state, and then Congress would have to approve of that.
And it was also your testimony that this bill is put into the wrong section, or it modifies the wrong section of law because the section we modify here is the initial bargaining unit section as opposed to the.
And I don't know that Illinois provides for while I'm licensed to practice law in Illinois, very rarely do as a rule. And I'm not aware that they have a unit clarification procedure in Illinois law for public sector. They may.
Okay, so either way though, right now your testimony is that as it stands right now, the mechanics don't have a remedy, and it's my question of you is, are you happy with that? Are you happy that, is it your position, is it the union's position that the mechanic members represented by your union should not have the rights that other workers have, because being vastly outnumbered by the drivers, they don't have the remedy of decertification. So what is their remedy, or are you just happy that they don't have a remedy?
No, not at all. The remedy, first of all, is an internal union matter. That is the remedy, internal union matter. There are mechanics who are glad that they are in a unit with the bus drivers. There are bus drivers who are glad that they are in a unit with the mechanics. There are bus drivers who I'm sure would prefer not to have the mechanics in, but it's an amalgamated union that was created. Well, now the ability, if this was in a private sector, then that's fine, they have the right. What we're saying is why we're opposed to this bill is that it doesn't get to the point. So why are we keep wasting time on this bill? It uses the union's money and resources.
Thank you. Okay, further questions of this witness, Senator Hummel.
I apparently did not understand the issue before this, but they're not asking for a new decertification. I mean, certainly that's a remedy, but they're looking, and they don't necessarily want to leave the union, but they're looking for a different bargaining unit within that union, a different.
That's my understanding.
So let me ask you as a point of process. Let's say that there's that separate group internally. Would it be a separate contract, or would it be a separate section of the same contract voted on separately by the two groups? How would that work?
So it would work. The union, and like I said, the president of the union is a mechanic and understands this issue. It could work in one of two ways. It could work as a separate contract completely. It could work as a section within a contract saying the entire contract isn't approved unless so many of the mechanics vote for it as well. Any sort of remedy or any sort of process is available, but it's an internal union.
I get it.
Yeah.
This is more for me. So let me put it another way.
They could separate the contracts out potentially. Union bylaws allowing.
Okay, so the bylaws would make a bigger argument. So I'm looking at everybody. Sorry, guys, I'm trying to get to the meat of this, but so let's run down the scenario that it's the same contract, but a different subset. So it's negotiated separately, but under the same contract. So two different sections. You guys, the mechanics vote against their agreement, and the drivers vote for it. What happens in that scenario?
In that scenario, as it exists now, the drivers vote on the entire contract, and the mechanics vote on the entire contract.
So if
in that
one group approves and one group disapproves, you're still going to be in the same position where you're still voting on the contract as a whole?
As it works now, yes, the way that they do it now, it negotiates and they do it as a whole, yes. And I mean, that's my understanding, that, yeah, okay. Right.
Okay. All right, thank you.
Further questions of the witness? Seeing none, thank you for your testimony.
Thank you very much.
Fill out your witness form.
Certainly.
Further testimony in opposition to Senate Bill 396. I'm sorry, to 358. Further testimony in opposition to Senate Bill. Testimony for informational purposes only. Senator, do you have concluding remarks?
Yes, I just make a few conclusions. One is, I guess, if everything was hunky-dory and everybody was getting together, we wouldn't be here right now. And the second conclusion that I take is if the Transit Union Local 788 really thought this would make a difference, why would they bother sending anyone up to testify in opposition to it? They wouldn't care. So those are my closing thoughts.
Yes, Senator, I've had a little bit of experience with these compacts, and I know they are very complicated. I'm sure you've spoken to lawyers who have expertise in compact law. It looks like we have a dispute as to what the law is exactly. So thank you. And this will conclude the hearing on Senate Bill 358. Our next bill will be Senate Bill 396 by Senator Wallingford.
Distinguished Chairman, honorable committee members, I'm State Senator Wayne Wallingford. I'm presenting Bill 396. I'm the state representative from District 27. And Mr. Chairman, I thank you for the opportunity to bring before you what is a very, very, very simple bill. Senate Bill 396 repeals the requirement that the Attorney General reside at the seat of government. It does that by eliminating 7 words from the statutes. The current law, which was written in 1835, imposed the residency requirement to ensure the Attorney General was present to conduct business at the Capitol. Our Attorney General is the first in modern history who already lives in the local area of the Capitol. Our Attorney General clearly satisfies that requirement since he resides within ordinary commuting distance, much like other state employees who commute to work. As a result, this 1835 law is no longer needed, and Senate Bill 396 eliminates the need for the residency requirement. Now, interestingly enough, the law only applies to the Attorney General and not to other statewide office holders. So my Senate Bill 396 removes this outdated law, and because it is so simple, I would request favorable consideration to be a consent bill. And that concludes my testimony.
Thank you, Senator. So it's my understanding that I believe since you filed the bill, the Attorney General has, acquired an apartment to reside here in Jeff City.
Right, he's trying to comply with what people feel that residency means to be in the capital.
But for this could come up in the future, and again, we now have things called cars as opposed to buggies or horses, and do you think it's more important that the AG be in proximity to the Capitol than the other statewide office holders?
I don't think his job is any more important than the governors or lieutenant governors or secretaries or treasurers or the auditors.
Right.
But for some reason, this was singled out. And of course, in the day of digital technology, quite frankly, he wouldn't have to even be here on a continuing basis. But he chooses to, because he's only about 20 miles away.
Okay, thank you. Further questions of the bill sponsor? Senator Ryan.
Just one question. If we remove this from the statute, is there still a requirement out there that requires him to be a resident of the state, though? Is that in a different section? Is that part of the Constitution?
A resident of the state?
A resident of the state. This isn't.
Yeah, he has to reside in the state.
Okay, is that that's in the Constitution?
I don't know if that's in there at all, but I think it is, because I think every office holder has to be a resident of the state.
I think so too.
Yeah.
Okay. Okay.
Senator Hummel, thank you.
It's my understanding, again, I'm just reading from my notes, but isn't the reason that he has to live within the seat of government because it's to establish venue for court cases. Am I not mistaken? And that
Well-
508 says that, 508.010 says that it provides that requirements for establishing venue for non-tort and tort suits as follows: actions in which there is no court alleging a tort venue is determined as follows: when the defendant is a resident of the state, either in the county within which the defendant resides or in the county within which the plaintiff resides, then the defendant may be found. So if he doesn't reside here, the venue established, is that not going to be in Boone County as opposed to in Cole in the 19th Circuit Court? Isn't that the case?
I wouldn't think it would change that.
It does, because that's how you establish venue.
I'm not an attorney, so I can't answer that, but I wouldn't think it would, it was 20 miles away, I wouldn't think it would make a difference.
I'm saying that we're going to shift all the court cases out of Cole County and it's going to go to Boone County is what's going to happen.
Yeah, I'll research that and
Okay.
see what the opinion would be on that.
Further questions? Seeing none, do you have any witnesses in
I don't
favor
believe there's anyone here.
of Senate Bill 396? Any witnesses in opposition to Senate Bill 396? Any testimony for informational purposes only? This will conclude the hearing on Senate Bill 396.
Thank you, Mr.
So I would move that we go into executive session. Do I have a second? Second by Senator Livelaw. All those in favor say aye.
Aye.
Those opposed say no. The ayes appear to have, the ayes do have it. You have, we're in executive session. I would first move that we take up Senator Keough's Senate Bill 329. Do I have a second? Second. Seconded by Senator Livelaw. Those in favor say aye. Aye. Those opposed, no. The ayes appear to have it. The ayes do have it. So Senate Bill 329 was Senator Keough's bill pertaining to manufacturers having dealer, what distributorships would be the word, within this state. And I believe since last session, committee hearing, Senator Livelaw, you visited with the senator from Cole, and
I did. I want to make sure that we weren't precluding other engine manufacturers from being able to have the same amount of repair facilities. It was mainly for diesel engines, and Cummins engine was mentioned a lot of times here, and there's many more diesel engine manufacturers from a lot of different types of horsepower and applications. I'm not going to name them all because I like doing commercials in committee meetings, but that was the thing that I was most concerned about. That I think I'm okay with the bill as it is.
Okay, great. Further, I guess I don't have to I would move that we move Senate Bill 329 do pass. Do I have a second? Second by Senator Livelaw. Mr. Secretary, call the roll.
Senator Onder.
Aye.
Senator Livelaw.
Aye.
Senator Brown.
Aye.
Senator Heigl.
Aye.
Senator Hummel.
Aye.
Senator Rizzo.
Aye.
Senator Watson.
Aye.
By a vote of 7-0, you have approved Senate Bill 329 do pass. And Senator Keough asked that his bill be considered for consent status. It doesn't create a penalty, doesn't have a fiscal note, and to my knowledge is not controversial. So I would move that we pass Senate Bill 329 consent. Do I have a second? Seconded by Senator Brown. Discussion? Seeing none, Mr. Secretary, call the roll.
Senator Onder.
Aye.
Senator Livelaw.
Aye.
Senator Brown.
Aye.
Senator Heigl.
Aye.
Senator Hummel. Aye. Senator Rizzo. Sorry, that's Senator Watson.
By a vote of 7-0, you have approved Senate Bill 329 do pass consent. And I would entertain a motion that we take up House Bill 291, Jared Taylor's House Bill 251. Do I have a second? Moved by Senator Livelaw, seconded by Senator Brown.
You just heard today, is that correct?
We heard that today. Of course, we heard Senator Brown's version of paycheck protection earlier in the year.
That's fine.
And
I really wanted some more time to think about it.
You did, okay. So, and I have is the bill before the body. I move that we bring the bill before the body. All those in favor say aye.
Aye.
Those opposed, no. The ayes appear to have it. The ayes do have it. And I have a substitute, Mr. Secretary, had we distributed it. Okay, the substitute rolls into House Bill 251, another bill that this committee is very familiar with, which is Senate Bill 210, the Chair's Public Sector Union Bill. It fits on it. It fits on the title. They're actually modify the same chapter, and be happy to entertain any discussion. Yes,
I'd be happy to. Okay, look, voting the same bill out we've already heard is one thing, but giving a sub and then saying, let's vote on it right now is.
okay. Well, yeah, we have
Nobody in this committee has had a chance to read it unless they're extraordinarily fast e-readers.
Okay, and the material in the substitute is substantially the same as Senate Bill 210, which we did.
Substantially, but not the same.
Not absolutely identical, because we had to make the changes to incorporate paycheck protection into public sector union or vice versa.
It's your committee, Senator, but I think that something of this magnitude that you just give us and ask us to vote on without anybody on the committee actually having read it is awfully fast.
Further discussion?
Move to do pass committee substitute.
Do I have a second? Those let's see, we need to adopt the substitute.
I'm going to move for it.
The adoption of the substitute is a voice vote. All those in favor say aye.
Aye.
Those opposed, no.
No.
The ayes appear to have it. The ayes do have it. I would entertain a motion to do pass the Senate committee substitute for House Bill 251.
So moved.
Do I have a second? Seconded by Senator Lidwell. Those in favor say aye.
Aye.
Those opposed?
No.
I'm sorry.
It's a roll call.
It's a roll call. Yes.
Senator Onder.
Aye.
Senator Lidwell. Aye. Senator Brown.
Aye.
Senator Eigel. Aye. Senator Hummel. Nope. Senator Rizzo. No. Senator Watson.
I vote 5-2. You have voted to do pass Senate committee substitute for House Bill 251. Further business before the body? Seeing none, I would entertain a motion to adjourn.
So moved.
Those in favor say aye.
Aye.
Those opposed, no. The ayes appear to have it. The ayes do have it. The adjourned laws committee is adjourned.